the live stream now and let in everyone from the waiting room. Good afternoon, everyone. We still have a few persons connecting. If you could bear with us a moment while we get everyone connected.
Very well.
All right. We have everyone connected who was in the waiting room. So I believe we're all here for 18 CA 4052 consolidated with 20 CA 5178. Tri-County Developments LLC versus Lopez. We are about 1 minute ahead of schedule, but we'll get appearances from who we do have. I wanted to note that this is being live streamed to YouTube in order to maintain public access to the court, so please keep that in mind. We have Christina Dooley of Merit Court Reporting as our court reporter today, and she'll have the official record of our proceeding. I'd like to get appearances starting with plaintiff.
Robson Powers on behalf of the plaintiff.
Thank you.
And Alvaro Sanchez, Your Honor, also plaintiff.
Thank you. And were you, do you have any client representative or any party for you, Mr. Powers?
Yes, our expert Sinead Thompson should be logging in. I'll double check with her.
I do see Sinead Thompson in the waiting room,
Oh, very well.
And Adam Stevens. So let's hold off until we get them in the room. We still have one person connecting. Let's hold on just another minute while he gets connected. See, Ms. Thompson, you're here as a client representative, or are you counsel?
Good afternoon. I believe that I am scheduled to testify as an expert witness on the 2 fee hearings as to reasonableness.
Okay, thank you, Ms. Thompson. So you're a witness. All right. Mr. Stevens, do we have your audio connected? Can you hear me?
Yes, Your Honor. It's Attorney Adam Stevens. The audio is through the phone. I apologize about that.
That's okay. I'm going to just finish renaming you Adam Stevens. All right. So if we could get official appearances from counsel for the defendants. That's you, Mr. Stevens, right?
Yes, Adam Stevens on behalf of Dwayne and Jennifer Lopez.
All right, and I think I see both of them in the screen. It says Jennifer Lopez, but I will rename them to include both of their names. And then I see Mr. Agnew. Mr. Agnew, if you can make your appearance for the record.
Good afternoon, Your Honor. I'm here on behalf of the various proposed garnishees: Extreme Painting and Contracting, Inc., Extreme Disposal, LLC, 7050 Pennsylvania, LLC, 4406 Southeast 13th Avenue, LLC.
So that's all of the proposed garnishes then?
There are others, Your Honor. Sanibel Captiva Community Bank and Powell, Jackman, Stevens, and McCarty, PA. I do not represent them, but I'll be raising the same. Some of those arguments will still be applicable to those entities.
So it's everybody but Sanibel Captiva Bank and the law firm?
That's correct.
Okay. I think that's everybody who I see present with us. Is there anybody who hasn't yet been identified on the record? No. Okay, so we're here on a number of motions. I'm going to ask anybody who's not actively speaking to keep yourselves muted. It will cut back on background noise and feedback. When you need to speak to the court or raise an objection or what have you, you can unmute yourself, or if you are having trouble unmuting yourself, you can always raise your hand to let me know that you're having an issue, okay? So I will turn it over to plaintiff's counsel with regard to, maybe you can tell me how you want to proceed with all these motions, and then we can go from there.
Certainly. If it may please the court, I think we could proceed with the motion for attorney's fees first. The first motion would be the November 25th, 2020 motion. That should be, and hopefully you have received our binder regarding today's hearing. That would be tab 2 of the binder. And I guess I would leave it up to opposing counsel to let me know if there is any objection to the figure that we've included therein, which is $7,052.50. If not, we are ready to proceed with testimony from myself and then from our expert witness, Shanae Thompson.
Okay. Stevens?
Yes, Your Honor, I had reached out, or I had my staff reach out to Mr. Powers, and I'm in agreement with those amounts. My client's in agreement with those amounts on both motions for the fees.
Okay, so to be clear, we're talking about the November 25th, 2020 motion for a total of $7,052.50, as well as the February 16th, 2021 motion for $3,928.75.
That's correct.
Okay, such that we don't need to have any testimony from Ms. Thompson? Is that correct?
The only issue would be the cost of our expert, Your Honor, in preparing for the hearing. She can testify as to what those amounts are, but we would ask that those fees from the expert be taxed as a cost in this case.
Any objection, Mr. Stevens?
No, I don't have any objection.
Okay, Ms. Thompson, I see you there on my screen. I do personally, I'm familiar with you and what you look like, so I don't think I need your driver's license in order to identify you. If you could unmute yourself, if you could raise your right hand. Do you swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Powers, go ahead.
Thank you. Can you state your name for the record?
Shanae M. Thompson.
And what do you do for a living?
I'm a partner at the Pavis Law Firm.
Okay. And have you been in touch with myself or the law firm Brandt, Dansky, Feithaler, and Sanchez in order to review attorney's fees incurred in two different appeals in case number 18CA 4052?
Yes, I have.
As to the first appeal, and that would be the appeal of the trial judgment itself, did you expend time and effort in reviewing and preparing for testimony here today?
I did.
And what was the time that you spent in reviewing and preparing for testimony today?
1 hour.
And what do you charge per hour?
$350 an hour.
And is that what you're seeking as a cost in this matter?
That is correct.
As for the second review that you did you also review the appeal of the attorney fee order in this case?
I did.
And did you expend time in that review?
I did.
And how much time did you expend?
Again, 1 hour.
And did you also charge $350 for that hour?
I did. And just so that way the court is aware, I am familiar with the underlying facts of this case. I did testify as the expert at the trial level. So that's why I had some familiarity with the facts going in. And it would typically, of course, take me longer to go through the information and get up to speed. But because I had that basic level of familiarity, I just needed to acquaint myself with the issues related to the appeal.
Very well. And did you charge those amounts to the law firm, Brandt, Dansky, Feithaler, and Sanchez?
Yes.
I have no further questions for this witness.
Stevens, any cross?
I have no cross.
Your Honor, at this time, we'd ask that the payments be taxed as cost in this matter.
All right, I don't believe Mr. Agnew has a position on that particular motion. Just want to confirm. I see you shaking your head no.
I do not, Your Honor. Thank you.
Thank you. All right, Mr. Stevens, any opposition to the additional, I believe $700 is being requested with regard to Ms. Thompson's services in preparing for the hearing today?
No, there's no opposition. I believe that the amounts charged is reasonable.
Okay, so I believe the ruling then would be that each motion is granted with for the amount stated in the motion plus $350 each. So I would need Mr. Powers to send in a proposed report recommendation that sets forth those amounts, granting both of those motions. Are you asking for a separate judgment, or are you asking that those amounts be included in connection with the other matters that are set for hearing today?
Pursuant to the judgment, they secured the attorney's fees as well, so that would be added to the total judgment amount in this case.
Any objection to that procedure, Mr. Stevens?
No, there's no objection.
But we would still want a separate order from the court pertaining to the attorney's fees.
Right. So I would do an recommended order granting the motions and then including those amounts in the, essentially would be an amended judgment or a supplemental judgment. I don't know what, we can talk about what we're going to call it, but it would be the new judgment that would ultimately be entered. It would include those amounts. And if there's no objection to that procedure, that's the way we'll do it.
No objection, Your Honor.
And I heard no objection from Mr. Stevens to handle it that way either. So I believe that would be all for Ms. Thompson, such that she can be excused. Just want to confirm that, Mr. Powers.
That is correct. Thank you so much, Ms. Thompson.
Mr. Stevens.
That's fine.
Okay. Thank you, Ms. Thompson. I hope you have a great day.
Thank you, you too, and thank you for allowing me to go first today. I appreciate it. Have a good day, everyone.
You too. Take care. Okay, so with regard to Mr. Agnew, do we need to wait to address his until after we address the amount of the judgment, or?
I think we do, because I think we need, sorry, this is Robson. I think we do because we need to establish the deficiency amount before we get into the writs and levies.
All right, do you agree with that, Mr. Stevens?
I would agree with that.
Okay, sorry, Mr. Agnew. If you you can work on other matters if you want to while you're here. It won't hurt my feelings. All right, so we'll turn to the, I believe it's the motion for summary judgment as to deficiency. I noted that there was an amended motion filed on April 2nd, which was included in the binder. I don't think that has a separate order of referral, but I believe it's a matter related to what was filed, as long as there's no objection from Mr. Stevens with regard to considering the amended motion. Mr. Stevens?
Let me see the amended motion. What is the amended motion?
It's an amended motion for deficiency judgment filed on April 2nd. I think the amounts are the same. Mr. Powers, if you want to speak to maybe the differences between the two motions.
Certainly, Your Honor. What we did is we amended that motion. It kind of provided a better breakdown and included some case law for the court's consideration. That was filed, like you said, on April 2nd, 2021, and it amends the, I guess, priorly titled motion for summary judgment as to deficiency. So this is the amended motion for deficiency judgment that we're seeking to hear today.
I think the amounts, are the amounts sought different, or are they
they are the same, and I guess the only change that we would be requesting would be that additional amounts that you awarded for the attorney fee expert. But other than that, the amounts and the calculation are the same in both motions.
Okay. It does look like the subtotal was the same, the $671,386.99 was the same, and then it generally referenced the appellate attorney fee motions, whereas the amended motion now includes those specific amounts that were stated in the motion, plus the expert fee that was awarded today. So that would be one modification, I guess. So Mr. Stevens, any objection to me considering the amended motion?
No, probably not. Let me check the docket real quick, Your Honor.
Sure. And if you need me to share my screen to show the document, I can do that as well if you can't find it.
When was the original motion filed? This was consolidated, so probably in the old case.
The original motion was filed December 1st, 2020, I believe.
Yeah, this has been filed numerous times in the sense that we filed it immediately in the original 18 CA 4052 case. And then when it was split, because we had a separate cause of action was filed, there's a separate complaint to establish the deficiency. Then there's a motion for summary judgment, and then we amended the motion to kind of help make things a little bit easier to follow, including the calculations and the case law all in one place.
So was the 20 CA case the independent action to establish the deficiency? Is that right?
That is correct.
And then those have now been consolidated for all purposes.
That is correct, by order of Judge LeBoda, Your Honor.
All right, I see that order was entered on February 26th, it looks like.
I'm sorry, you said December. I'm looking at the 18 case.
The one that I have on my docket, I believe, was the motion for deficiency judgment. It was a motion for summary judgment as to deficiency. I'm sorry, it was November 25th, 2020. I think I was looking at a different motion when I said the December date. So November 25th was the original one, and the amended one was April 2nd, 2021. And I think those were both filed in the 18 CA case.
That is correct, Your Honor.
No, I have no objection to that.
All right, well, thank you for confirming that on the record, Mr. Stevens. So I will go ahead and consider the amended motion filed April 2nd, 2021. And I'll turn it over to you, Mr. Powers, for argument or other presentation on that.
Thank you very much, Your Honor. Judgment was established in this case back in November 27, 2019, and the judgment amount at face value anyways was around $800,617.04. The property was then put up for auction in December 27th, 2019. And we have an unusual set of events that kind of take place afterwards. The defendants, through an LLC that they own, 7050 Pennsylvania, purchased the property and were the highest bidder at that auction. And they purchased the property for $275,100. And I say it's unusual because we don't normally have debtors who purchase the property. We believe that for today's purposes in establishing the deficiency, it's a purely mathematical equation that needs to take place because the amount of the bid, $275,100, is undisputedly less than the judgment amount of the $800,000 secured by interest, attorney's fees, and costs. For the court, we have provided a calculation in our motion to kind of break out how we arrived at the number. In the motion itself, and we tried to put interest through today's date of April 20th, it was $724,423.54 as the value of the judgment and the amounts due and owing to the plaintiff, with full credit of the $275,100 from the defendants through their LLC. Now, what we move, and we would ask the court to take judicial notice of its own records pertaining to the file and specifically the foreclosure auction. What we ask the court to take judicial notice of is the bid sheet that confirms that the highest and successful bid price was $275,100, that the final bid was made by 7050 Pennsylvania LLC, that the Sunbiz filing records pertaining to the company reflect that the owners of the LLC are the defendants, Jennifer Lopez and Dwayne Lopez. In establishing that a deficiency exists, we believe that the court simply needs to follow the calculations that's set forth in the motion, to not give the defendants a windfall or a credit of some sort to establish a different price than the price that they purchased through their own LLC, because the $275,100 through the bid is the fair market value as established by the case law that we included in our motion. If the court would like me, I can go through to argument as to why that is, or I can reserve that for later on. I'll leave that to the court to direct me.
Are you, this was noticed as an evidentiary hearing. Are you presenting any evidence in that regard, or what is the
We
Where are you
we are
going with that?
certainly, we're presenting the foreclosure bid price as proof of the fair market value of the property on December 27th, 2019, and the court can take judicial notice because that it's filed within this own record.
Okay, so the only evidence you're actually relying upon is, I guess, the judicial notice of the sale price, right?
That is correct, to establish the fair market value.
Okay, Mr. Stevens, any objection to me taking judicial notice of the sale price? Oh, hold on a second. I had muted you because I was hearing some background noise. *6, I believe, to unmute yourself. Go ahead. Oh, I still can't hear you even though you're unmuted. There you go.
Now, can you hear me?
Yes.
Okay. I apologize. I forgot to mute it earlier. Objection just to the amount on the certificate of sale?
Right. He wants me to take judicial notice of the amount. I guess it was the successful bid price at the foreclosure sale.
I believe it's a court record. I don't have any issue with the amount that it sold for.
Okay. So you have no objection to me taking judicial notice of that?
Just the amount, I do not.
Okay. I had somebody pop up in the waiting room. Gizzi. I'm not sure if they're related to this proceeding.
That would be a witness for us, Your Honor.
Okay. Well, let me let them in then. Okay, so, and then you're essentially resting Mr. Powers, such that I would look to Mr. Stevens for any evidence he wants to present in opposition to your motion?
That is correct, Your Honor. Our position would be that there would be no additional evidence necessary.
Okay. I've just let in, I believe this is the witness. It's last name Gizzi. Sir, if you could unmute yourself and give me your first name so that I can include your first name.
Yes, it's Mark Anthony Gizzi, M-A-R-C.
M-A-R-C Gizzi.
Correct.
Okay, hold on just a moment. Okay, so Mr. Stevens, as I understand, there's no other evidence presented by the plaintiff. Is there any evidence that you are seeking to present in opposition to the motion?
Yes, potentially. I'd like to make an argument first.
Okay.
I'd like to direct the court's attention to the order granting Garnishy's emergency verified motion for reconsideration or clarification and objection to garnishment that was entered by Judge Laboda. I believe the filing date kind of cut off at the top of my page. I believe it's July 21st, 27th maybe of 2020.
What was the name of the document?
It's an order from Judge Laboda, order granting Garnishy's emergency verified motion for reconsideration or clarification and objection to garnishment.
I think I have that one. I think it's July 21st, 2020.
Yes, it's either the 21st or 27th. It cut off on the top of my page. I apologize.
Okay, I found
I'd like to direct. Ultimately, what happened here is there was a foreclosure judgment entered, which I'm sure the court's aware is not a personal judgment. It's a judgment of foreclosure, just signifying the amounts due and owing. Then there's a sale, and typically there would be 1 year to file for a motion for deficiency judgment. Here, typically there would also be a reservation in that motion for summary judgment, or the order granting the motion for final summary judgment with the reservation. Here there was no reservation for the deficiency judgment. So the year is not applicable. What actually happens is they have 10 days from the certificate of sale to file their motion for deficiency judgment. And that is detailed in my motion and all the case law and everything.
Which motion are you referring to?
My motion from, this one does not have a timestamp date on it, so.
Was it the motion that Judge Labota's order was entered upon? Or-
No, it's our memorandum in opposition to plaintiff's motion for summary judgment, and I apologize. I'll find it here.
Okay.
Well, I can locate it, but ultimately it states, if the court does not retain jurisdiction to enter a deficiency judgment as set forth in ALUA, which is Aluia versus Dick O'Neill, then the mortgagee must timely file the motion for deficiency judgment within 10 days of the certificate of title being issued. And that is in accord with Frumkiss versus The Mortgage Guarantee Corp., 173 Southern 2nd, 738, 3rd DCA, Florida, 1965. That case held that the trial court's denial of the deficiency judgment because it was not filed within the period allowed 10 days from the date of the certificate of title being issued was eminently correct and is affirmed. So ultimately they have 10 days to file the motion for deficiency judgment. They did file a motion for deficiency judgment, and it actually was within the 10 days. Then they, if you look at the docket, they essentially removed that motion. So there was no motion. So our position here, and what the judge has ruled in the order that you're referring to, and I'll point that out in a second, is that they don't have jurisdiction to seek a deficiency judgment at this time, ultimately because there was no motion that was pending, other than the withdrawn one within the 10 days. Then they subsequently filed another one well beyond the 10-day period. And that is delineated in so that was that was ultimately, the motion for deficiency judgment was ultimately denied. I believe that this motion should be denied as well because it's already been denied by Judge Labota under those grounds. The avenue that they have is to seek an action on the judgment. They have to do that within 1 year. They have done that. But what they're trying to do is circumvent the procedure to ultimately seek the action on the judgment by now filing a second motion for deficiency judgment, which I believe the court has already ruled upon, and this motion should not go forward based upon that. They can certainly get this on a trial track and get it to a trial posture by the filing of the other case back in September, I believe it was. But this motion has already been denied. So I believe that we have res judicata or collateral estoppel certainly on this issue that the judge has already entered based upon those grounds.
Okay. Rebuttal to that argument, Mr. Powers?
Certainly, I think it misses the mark. The court could take judicial notice that we filed a separate action to collect the deficiency on August 7th, 2020. That case, after a hearing with Judge Labota, was consolidated back to this case, 18 CA 4052. We then filed the amended motion for deficiency judgment to have the deficiency established by the court. The arguments raised by Mr. Stevens have already been litigated, have already been addressed by Judge Labota, and that's why we filed the independent action and subsequently consolidated it back to this action. So we are in the proper place, time, and forum to address the motion for deficiency judgment here today.
So there's been a lot of history here that I'm trying to catch up on. So as I understand your arguments, Mr. Stevens, the motion for deficiency judgment was previously denied in the 18 CA case, which I believe is what prompted the 20 CA case. And your assertion, Mr. Stevens, is that this motion is not the proper procedure for obtaining a deficiency judgment in the 20 CA case, that it should be some other procedural mechanism. Is that accurate?
Yes, and the order was entered on June 2nd, 2020, where Judge Labota denied the motion for deficiency judgment based upon a lack of jurisdiction, a lack of reservation. So yes, I believe just because they filed a separate action and now have consolidated it into the 18 case, it doesn't allow them to circumvent the procedures that are set forth with filing a separate action on the judgment. So I believe it needs to either be summary judgment with affidavits, or it needs to be in a trial posture. They haven't produced any affidavits, so I don't believe that they're entitled to it. I believe the judge has already ruled on this.
Certainly,
Mr. Powers?
I guess we're a little confused as to what avenue would be appropriate if the trial judge said we need to file an independent action, which we did, and that action has been consolidated into this case. And we now have taken judicial notice of the bid sheet, and it's a matter of calculation as to what the deficiency amount is. This is an $800,000 judgment with a bid that was $275,100. It doesn't take a rocket science to determine that there is a deficiency here that needs to, be established by the court. The defendants have been playing this game of delay, deny, and defend, starting up 2 appeals in this case that were denied per curiam, and now going to these lengths to try to avoid establishing the deficiency amount, because they know that once that is established by this court, whatever that number is, that we can then proceed with collection. And so this is all a mechanism to avoid our creditor right to proceed with the judgment that is fully enforceable and has been enforceable since November, Your Honor. So we're ready to proceed today. This was noticed for today. There's been no objection to this hearing. There's been no written document saying that we couldn't proceed today. So we're taken a little aback that now at this final hour that we can't proceed with the motion for deficiency that's been set by Judge Loboda with opposing counsel present. And that's why this motion was consolidated into one block of events on February 26, 2021. Those issues should have been raised by counsel to the judge there, and it was not. And so there's no issue here, Judge. We can proceed with the motion for deficiency judgment and establish the deficiency. If there was any issue, that should have been addressed prior to the court consolidating and allowing, per her order, this court, for you to hear and entertain the motion for deficiency judgment today.
Okay.
If I may.
Yeah, go ahead.
There's a rebuttable presumption on the certificate of sale. I mean, we all have been people that dealt with foreclosures have certainly seen property sell for $100 at auction back to the plaintiff. Just because their motion is set for hearing doesn't mean that there aren't arguments to show that it's already been decided or there's no jurisdiction for the court to hear it at this time. These are things that, respectfully, counsel should be aware of moving forward with how the process and procedures work with foreclosures.
Your Honor,
There's no application.
Don't talk over each other, please. Go ahead, Mr. Stevens.
It's been ruled upon. They're circumventing again the procedure here by filing a simple motion with no supporting affidavits as to the amounts under a summary judgment type proceeding. Otherwise, there'd be a trial. There's only 2, or a judgment on the pleadings, which hasn't been filed. There's only 3 ways to dispose of a case.
All right, Mr. Powers, was there something else you wanted to add?
Yes, just the order on judicial status conference and consolidation of cases specifically says in paragraph 3, plaintiff further requested that all pending motions must be heard at the same time and during the same hearing. As defendant's counsel did not object to this request, the following matters are referred to the magistrate and are to be heard at the same hearing and in one setting. We're ready to go today, Your Honor. There's no issue of preventing us from the determination of the deficiency amount.
Okay.
I'm not objecting to the magistrate. We're here and I'm having the hearing.
So as I understand the arguments, Mr. Stevens is not disputing that the matter was supposed to be set or heard today, but that he disputes the substantive relief requested in the motion, at least with respect to the 20 CA case, because under a complaint for deficiency, you wouldn't have a motion for deficiency. That's what's usually filed in a foreclosure case to have the deficiency determined. In a separate count for foreclosure or for deficiency, the ultimate issue in the case is the deficiency. And I tend to agree with Mr. Stevens that the way you get a final judgment on a complaint is summary judgment or trial, or sometimes you can get a motion on pleadings, but that's pretty rare. This current amended motion does not reference the summary judgment rules. So I don't think it's a motion for summary judgment. And otherwise, the only other way to get a final judgment is trial. So I think I agree with Mr. Stevens that procedurally in the 20 CA case complaint for deficiency judgment, this is not the proper procedure for obtaining a final judgment. And that the motion with respect to the 18 CA case has already been denied before for lack of jurisdiction or reservation with respect to a motion.
Right. There's no questions of fact here. The $800,000 judgment with a $275,000 foreclosure auction.
But the argument asserted is a procedural argument regarding how do you get the judgment. And the only ways I'm aware of getting a judgment is a motion for default. I'm sorry, motion. I guess there could be a motion for default, but that's not the case here. We have defendants who've answered. Was there actually an answer filed in the complaint in the 20 CA case?
I will state that our motion specifically asks for a deficiency judgment, and I think the court can.
Well, let's back up, Mr. Powers. Your complaint, the operative pleading in the 20 CA case asks for the entry of a deficiency judgment. That is the ultimate relief requested in your complaint. Then it appears there is a separate motion. Let me see. Actually, no, the current motion is filed in the 18 CA case because of the order consolidating, but and actually it doesn't cite the 20 CA case on it. Your amended motion for deficiency judgment filed April 22nd doesn't include the 20 CA case number on it.
Because it was
consolidating cases does not merge them together and make them one case. It consolidates them for purposes of proceedings, but they still retain their independent legal status for purposes of the claims pled and the defenses pled, is my understanding. Do you disagree with that analysis, Mr. Powers?
I would say for purposes of the docket that we can file an 18 CA 4052 for both matters because they've been consolidated by the court into one case.
I don't think they're consolidated into one case. That's not my understanding of what consolidation does. You still have independent complaints, answers, etc. But I don't see an answer filed to the complaint in the 20 CA. I mean, I still think there needs to be an answer filed. Have you not filed an answer, Mr. Stevens?
Yeah, I just noticed that I have it here, but it has not been filed. There was a notice of appearance filed. But I will certainly file one today.
Your Honor, and if the court is going to see this differently, then we ask that you see this as a motion for summary judgment as to the deficiency amount, and which is what the request for relief is.
Your request in the amended motion?
That is correct, Your Honor. We asked.
It doesn't reference summary judgment at all. It doesn't cite to the rule. It doesn't cite the record evidence. I know you're not relying on affidavits, you're relying on the sale price, but the motions for summary judgment have to be specific. They have to put the other side on notice that that's the type of motion you're filing. Plus, summary judgment, the motion has to be filed at least no less than 20 days before the hearing on the motion. So you can't rely upon an April 2nd summary judgment motion to be heard on April, what's today, 20th? Not 20 days. So I'm gonna have to agree with Mr. Stevens that this is not the proper, so as to so what's before me right now, by agreement of the parties, is the April 2nd, 2021 motion. That's what was asked to be heard, and that was what was agreed to by Mr. Stevens. That motion does not specify that it's summary judgment, but assuming that I were to consider it as that, it's not stated in that way, it's not timely set for hearing today. The court's already denied a motion for deficiency in the 18 CA case based upon lack of jurisdiction and reservation, such that I would deny the motion to refer deficiency in connection with the 18 CA case. To the extent that that motion is also asserted in connection with the 20 CA case, I think it's premature for me to be able to hear that. Again, it's not properly noticed as a summary judgment hearing. It would have to either be a summary judgment hearing in accordance with the rules, or it would need to be noticed for trial. Notices for trial require 30 days notice, and I think it's going to have to be reset under that posture. And I will know that when I hear deficiency trials, there's usually a special notice of hearing that's used for deficiencies. Now that's in the context of motions for deficiencies, but I think the same argument applies. It's a 30-day notice for trial. Everybody understands that it's a trial on the matter, and that's if the parties dispute the fair market value. So, and I'm not going to get into whether I actually have to consider fair market value, because I know that's one of the disputes between the parties. Mr. Stevens, I assume, wants me to consider fair market value, and Mr. Powers wants me to rely upon the sale price. But my ruling today is based upon the procedural posture of this case, or cases, because they are, although they are consolidated cases, they're not joined together, and the pleadings for each respective case remain pending for determination. So even when cases are consolidated, you still usually will have a separate evaluation of the judgment as to each claim or that's asserted in the respective cases. So to summarize, on the amended motion for deficiency filed on April 2nd, I'm going to deny it as to the 18 CA case because it's already been ruled upon and denied by Judge Laboda before. I'm going to also deny it as to the 20 CA case as the improper procedure for bringing this matter to the court, either by way of summary judgment or trial, or any other method of obtaining a judgment pursuant to the civil rules of procedure. So with that, I'll let you all renotice it. And if you think you want to pursue summary judgment, you can file it that way, Mr. Powers. If you think you want to just notice it for trial, just notice it for trial. We can get it addressed. But I want it before me in the proper posture so that we're all on the same page about what the legal standard is, and so that there's no procedural issue that would provide a basis for appeal because people weren't provided the right notice or put on notice as to the type of proceeding that was being conducted.
And just for future reference, do you want us to file filings that are in the 20 CA case with the 20 CA in our headings? I just want to make sure we're all on the same page.
Yeah, normally the heading will continue to have both case numbers in it. To the extent that you're filing the document for both cases, it should include both case numbers. Now, I have seen cases that are consolidated for certain purposes, or if you're only asking for a certain relief in one of the cases but not the other one, you still file it in the main case that it's been consolidated into. But if the relief only pertains to one case, then I think you only have to include the case number for the case where you're seeking the relief. The order consolidating, it consolidates it 20 CA into the 18 CA, and it doesn't actually say for all purposes. I'm going to assume that it's for all purposes. But even if it's consolidated for all purposes, the cases don't lose their independent status as a cause of action or as an action. So I will do the report and recommendation myself on that motion. Given that, does that moot, for at least for today's purposes, the other two motions, the motions for writs of garnishment and for levy and execution?
Yes, we will not hear them at this time.
Okay, so I will do the report and recommendation then as to 3, 4, and 5, what I marked as 3, 4, and 5, and I'll just note that 4 and 5 are moot for now, based upon my finding as to number 3 being the amended motion for deficiency. Are there any questions, clarifications? I know we've been through a lot of stuff today. I will ask Mr. Powers to send me a report and recommendation on the attorney's fees motions. Given that the court is not proceeding on the deficiency, do you want a separate judgment on those, or are you still going to wait to have those included in the deficiency judgment once the court hears that?
I think we would like an order, and then an order on the judicial notice as to the case file in the bid sheet, or the bid sheet.
When you say order, do you mean judgment, or you just want an order granting the attorney's fees?
Order granting the attorney's fees.
Mr. Stevens, any objection to any of that? Oh, I couldn't hear you.
No objection.
Okay, so Mr.
No.
Powers, whatever order you want to have entered separately, send it in. If you want it separate from the report and recommendation, I'll need you to send in the report and recommendation and any separate order that you want the court to enter. As I said, I will do the report on the deficiency motion as well as the other 2 execution related motions, just noting that those are moot. Mr. Agnew, you filed a notice of appearance in the case? Is that right?
Your Honor, yes, I've been involved in the case since the spring of last year. There were previous motions for garnishment and for levy and execution where I appeared.
Okay, I should probably ask you to confirm that you have no disagreement or dispute that the 2 motions are moot, given the court not proceeding on the deficiency.
I agree with that position. Thank you.
Okay, thanks. All right, so any other questions or clarifications while we're still on the record today? Mr. Powers?
No, Your Honor.
Mr. Stevens?
No, Your Honor.
Mr. Agnew?
No, thank you, Your Honor.
All right, I will note that the exception period is not waived. And that will be all for today unless we have anything else.
Well, that's it, Your Honor.